Welcome to Under the Rug at Work, where I shine light on problems that are normally swept under the rug. Today, I'm chatting with Peter Pham about human rights at work. Peter is the principal lawyer at Mart's Method, which is the only non-government funded human rights law firm in Australia. Wow, thanks for joining me, Peter.
No worries, Nicole. Good to see you.
You too. So, why did you start Mart's Method and what does it mean?
So Ma'at or Ma'at is the ancient Egyptian or Kemetic deity of truth, justice, and balance. So it's a representation of primarily balance, but in our spirituality, balance is at the core of truth and justice. Mm-hmm. The reason I started Ma'at's Method is mostly because in a broad sense, I wasn't willing to compromise on my values. And in the process of becoming a lawyer, and even becoming a human rights lawyer, which was always my dream, I still felt like there were boundaries and rules being cast around the truth and cast around what I was allowed to do and say. And when those boundaries became explicit and I was essentially given the choice of censoring myself and not censoring myself in terms of my words and actions, or doing what I knew to be true and also what I knew would genuinely help people, I chose the latter. So I originally worked in private practice, and then after that I worked in the human rights specialist team at Legal Aid, which is a government-funded legal service. And as you said, most human rights, actually all human rights practices, dedicated human rights practices in Australia are government funded because human rights areas, in terms of the way the legal system's set up, generally aren't very lucrative. So the only way to maintain a practice in those areas is if you receive government funding through grants. But the problem there, the conflict, is that the most egregious breacher of human rights in Australia and most countries is the government. So there's a conflict there, and that led to barriers in terms of what I was allowed to do. So even though there are good people that work at Legal Aid who do good work, and there are genuine areas of human rights law that they address, there are other areas that you're not allowed to address. And particularly in the controversy of COVID-19, there were areas of human rights work that I wanted to address that we weren't allowed to address. And also there was a vaccine mandate that was brought in as well that I didn't want to comply with personally. So I decided that the only way to work as a lawyer in a way that wouldn't compromise myself was to work for myself. So I took the, at the time, quite scary decision of starting my own law firm and just trying to do what I wanted to do, which was based on my North Star, which is, who am I? Who are we? And what are we doing here?
I love that. And I think that's why we connect as well is I'm very much a morals and ethics based person. And I've worked for some organizations that have not aligned with my personal values. Obviously, my business is in the area of bullying and harassment, and I have witnessed and experienced bullying, harassment, and discrimination in many workplaces. And it's gotten me in a lot of trouble speaking up and speaking out because I can't see something and not do something about it, especially when I get that feeling in my gut, or like I remember multiple, but one particularly bad experience where I lost 5 kilos in the space of 2 weeks because of what was happening in the organization. And I voiced my concerns. But like you, there is a corporate line that's you kind of can't cross. And if you do, then yeah, I've got myself in a lot of trouble from doing that. But I admire what you have done, and I admire everyone who has the courage to speak up and speak out, not only for themselves, but for others. And that's where my title came from, Chief Courage Officer. And I want to help people, have the courage for themselves or for others.
Yeah.
And yeah, I just want to commend you on that, because it is hard to go against the grain, and to not do what you're told.
Yeah,
I
thanks,
think
Nicole.
it's
Even though it takes courage and it is hard, the thing that you and I have experienced, and other people who have taken the same path have experienced, is that every time you make an authentic decision, and this is something that has really been reaffirmed for me over the past sort of 2 to 3 years, every time you make an authentic decision, which is initially challenging or difficult or brings uncertainty and anxiety, when you take that step, and it only has to be a very small step, your life gets better, because you find yourself living more in alignment with who you actually are, and you're distorting things and being manipulated by external things a little bit less, so you have a bit more freedom. And that's extremely empowering and liberating, and most people who get a taste of that don't really want to go back to any other way of life. And it becomes kind of addictive, and you just completely put all of your energy into chasing who you are, and cutting off anything that might be compromising that. So it is initially scary, but every time I've made the decision to take that leap, my life has gotten much, much better as a result.
Yeah, you've nailed it. You've nailed it, because I think I am addicted now.
Yeah,
But
yeah, yeah.
both you and I wouldn't be where we're at, and in the organizations that we're in and leading, if we hadn't stood up and said, I don't accept that, or that's not right, or that goes against, my personal morals and ethics. So yeah, if anyone listening, I just want to share, if you're feeling scared, we feel you.
Yeah, yeah.
You
Yeah, yeah.
can definitely speak up, and it does get easier. And both you and I, Peter, help people speak up and speak out, and give people the tools to be able to do that. So yeah, I think that's why we connected, and I encourage people to choose their North Star, know where it is, and do that, because yeah, it is courageous, and it is life-changing, and it is life-changing in a good way. Yeah.
Yeah, absolutely.
So the last few years has seen the best, I think, of people, and the worst. Can you share your insights when it comes to the workplace? How has the landscape changed over the years?
Australia's got a really interesting history when it comes to the employee-employer relationship. One of the flow-on effects, and I guess consequences of Australia's founding, is that there's a bit of a prison officer convict dynamic. That obviously Australia was founded, westernized Australia was founded as a prison colony, and in a prison colony there are prison officers and convicts, and that dynamic still bleeds through in many aspects of our society. And in the employer-employee realm, I thought up until probably 2 to 3 years ago that was one of the areas where there was actually a lot of good foundations around the rights of employees as opposed to employers, at least compared to other Western countries and other countries in general, where a lot of the individual rights of employees were heavily valued and clearly enshrined particularly in common law and case law, some of the precedent that stretches back many decades, but also in the union movement in Australia, and the fact that we have awards, we have one of the highest minimum wages in the world. Of course, the cost of living is also very high, but nonetheless, the minimum wage is very high in Australia. And in general, we have a culture that traditionally has valued employees and was more balanced in that way than a lot of other places around the world, like the United States, for example, where as an employee, you have traditionally many less rights than you do here in Australia as an employee. And that's part of the reason why there's so many people from overseas who want to come and work in Australia, because the conditions, the benefits, the wages are generally pretty good. To give an example of that, up until recently in the common law and the case law, and the private life and private choices of employees were always held in very high regard by the courts. There's been a few cases around whether an employer can force an employee through a direction at work to undergo a medical examination, for example. And there's a long line of case law, starting with a case, or at least starting in recent history with a case, a Steve Doring case in the High Court, where the court emphasized that employers must be very, very, very reluctant to intrude on the personal private lives of their employees. And indeed, they're only allowed to do that in very particular circumstances, where it's actually necessary in order to offset some other significant risk, and particularly a risk that the employer has some expertise and knowledge regarding, so that they can actually, the thing that they're implementing, which impedes on the individual rights of the employee, they understand completely and have adequate knowledge to know that risk mitigation control, whatever it is actually going to meaningfully impact that risk. So there's a lot of case law around that. And one of the things I've been disappointed by in the last 3 years, because I'm not an employment lawyer, I'm a human rights lawyer, and I was a human rights lawyer before COVID started. But when COVID started, the little bit of employment law that I had done before that led me to realize that one of the major areas of human rights disputes in the past few years has been employment law, because their employers were put into a position, and in some cases voluntarily took on the position of intruding on the personal lives of their employees by either wanting to access private medical information of their employees, wanting to implement directions for their employees which would force them to undergo medical procedures, and in other ways as well. And to me, those practices were clear contraventions of the previous case law in those areas, and did not align with the way that the law had previously been applied, nor with the statutory definitions that the case law was interpreting. But nonetheless, I'm probably going a bit beyond the scope of the question, but I've found that the way that the law has been applied in the last 3 years has negated, in my opinion, the integrity of the law, in the sense that previous precedent, which would have suggested that the statute was to be interpreted in a particular way, has essentially been ignored, and in its place has been the sensibilities of the time, meaning the general popular societal opinion about a controversy, which is the pandemic, has resulted in a particular interpretation of the law, which I don't think is consistent with decades of legal jurisprudence and precedent. So that has led to me forming a different view on employment law and the meaning of the precedent in employment law in Australia. And I think that the past few years, unfortunately, has seen a huge dilution of the rights of employees in Australia in a legal sense. Simultaneously, however, it has also led to a huge awakening and realization amongst people that maybe the protections that they were relying on aren't very reliable, and instead they might have to look internally for some of that protection rather than externally, meaning make choices to protect their autonomy and integrity through becoming more independent rather than relying on external systems to provide that kind of protection. People have realized through what's happened over the past few years that some of the protection they were relying on from external sources is better found through a more personal and creative internal approach. And the point there being that the protection that I would have probably said was there through the Work Health and Safety Act, Work Health and Safety Regulations, that's in New South Wales, but there's equivalents in all the states and territories that are all very similar, and through the common law, which is case law that sets in place interpretations of that statute, where the courts say, this is what Section 17 means in the Work Health and Safety Act. this is what the primary duty of care is, and so on. I think that's been pretty fundamentally changed now, in a negative way for employees.
And I've worked for a couple of regulators, and the legislation is so confusing. To a layman, you need a lawyer to interpret it, but then it still comes down to the lawyer's interpretation, and then who wins at that interpretation? How can it be fair and equitable if it is based on interpretation? And there is that ability to go down the direction in case law in one area and then make a completely different assumption or interpretation in another.
Yeah, this is a great excuse for me to talk about human rights, because you're speaking to is a fundamental problem within the legal system in its current form in Australia, but not just in the legal system, it's in many systems in this society. If you go back, so there's jurisprudence is the philosophy of law, that's what it means. So it's like the foundational principles of legal systems in general. Because if you think about the discretionary nature of our legal system, and the uncertainty that creates and the inaccessibility that creates, because a lay person can't just go to court most of the time and put forward an argument against some barrister who's an expert at bending the law to suit a certain set of facts, and then a judge who may then interpret the law in a way that's accordant to their own sensibilities, and you need $100,000 to do it anyway. All of those problems don't necessarily exist in the seed of the legal system and the systems that fed it into existence. So in most ancient older societies, and we don't have to go that far back, there were non-derogable human rights principles. So there were certain principles that collectives of human beings said, no matter what, these principles cannot be diluted or distorted or accepted from. There are no exceptions to these principles. So one example of that, a traditional example of that is the right to life. Another example of that, which is traditional, is free will, which in modern terms we call self-determination. And there are lots of them. Those principles form the foundation of the international human rights covenants and treaties that Australia is now a signatory to, like the ICCPR, the International Covenant on Civil and Political Rights, for example. But the ICCPR has exceptions in it. So somewhere between Roman Greco societies and you come to Milton and some of the philosophies around early legal systems, exceptions were introduced into the mix, and the law in general became a lot more discretionary. And that's not all bad, because it does allow for flexibility, but flexibility usually is implemented in a discretionary way by those in power. And unfortunately, that tends to lead to corruption or decision making, which is distorted. And that's why many of those older societies didn't allow for that, because they knew the risk of allowing that inherent flexibility would be too great. So yes, what you're saying is 100% true. And I've had that experience many times as a lawyer, where I think the law is saying something very, very clear, but the way that it's interpreted leads to a different outcome. And it is so discretionary in many areas that almost anything can be the outcome, which means that the population doesn't have a really clear barometer or foundation themselves of what's actually lawful and what's not lawful. I'll give you a quick example of that, which is just to make it real. In the Work Health and Safety Act, there's a primary duty of care, which is the duty that every employer has to mitigate risks in the workplace as far as reasonably practicable. There's a pretty set in stone common law interpretation by the High Court in Australia of what that means. And one of the things it means, according to those cases, is yes, an employer has a duty to mitigate risk in the workplace to keep their employees and customers safe, but only to the extent that it's reasonably practicable. What does reasonable practicality mean? One of the things it means is that an employer has to have a sufficient state of knowledge in order to understand the actual measure that they're implementing. So this goes a little bit back to what I was saying before. In order to sufficiently understand the measure that they're implementing to mitigate the risk. If they don't actually have knowledge about some kind of risk mitigation strategy, they can't be expected to implement the control to mitigate risk, because they're not going to know what it means. They're not going to understand it. The implementation is going to be clunky, and it's not actually going to have any positive impact on the workplace. Nonetheless, almost every employer in Australia, not all of them, but almost every employer in Australia over the past couple of years, despite having no expertise or knowledge in vaccinology, virology, epidemiology, public health, used the primary duty of care as a justification to implement policies mandating vaccination for their staff. So human resources professionals with no understanding of medicine told their employees that in order to continue to work for them, they had to undergo a provisionally approved medical procedure, because they said they had to comply with their primary duty of care to mitigate risk in the workplace. That's an interpretation of the primary duty of care that completely ignores the case law around reasonable practicability. And it's actually really bad for the employers, because now what they've done is in a huge way broadened the scope of their own duty of care to their employees, because the way that it's now been interpreted, employers have to essentially mitigate any risk in the workplace, including risks that have to do with things they don't understand and don't have any knowledge about. So if there's ever any other virus that spreads around or any other emergency of any kind, arguably employers have taken on themselves the responsibility of mitigating those risks by implementing extreme control measures such as mandatory medical procedures for their employees, which is a very extreme measure. To tell your employee that they have to undergo a private medical procedure to keep working for you is historically unprecedented and a huge measure and a huge leap forward in terms of that employer-employee relationship. So that kind of uncertainty in the law can lead to very confusing outcomes, and it can lead to weird pivots and diversions on what the law actually means. And the more that happens in a way that's not consistent with the precedent, the less meaning the overall legal system has. It takes away from its legitimacy and integrity, because it seems like there aren't really any rules that are being followed. And if a game has no rules, it becomes chaotic and people don't want to play the game anymore. So
yeah, that's a really interesting take on it. I've not heard that before. But when you started talking about, the PCBU and the responsibility for primary duty of care, my initial thought to that was workers also have personal responsibility to make sure that they're being safe, and that they have this responsibility to make sure that their work environment is safe. So that's psychologically and physically. But that broadens it, yes, so much. And that the work from home line, I think, blurs things as well. I used to think exactly the same. The responsibility line was quite clear, and now where is that? That's a really interesting take on things. Thank you for sharing.
no worries. I don't know where the line is now. I thought it was in a particular place as well. Well, what I would say is that employers, because in most states and territories and in most industries, there weren't public health orders, i.e. government orders, which, because where there was a public health order forcing an industry, for example, to have a mandate, that does put employers in a generally very difficult position, because they still don't have to implement it. But if they don't, there's a question around whether they're in conflict with state laws, and it could be very messy. And in those circumstances, what are they supposed to do? It's really difficult. But where there was no public health order or direction, which was actually the case in most industries and in most states and territories, and they voluntarily took on the responsibility and the duty, and even explicitly said that the reason they were implementing the policy is and they all use slightly different language, but because they had to be in compliance with their primary duty of care under the Work Health and Safety Act. That's a really dangerous precedent to set for yourself as an employer, and a very dangerous precedent for all employers collectively in Australia to set for running businesses and the Work Health and Safety Act. It really needs to be clarified through a federal court or high court decision, probably, which hasn't actually happened in that context yet. Or better yet, some kind of legislative change, but that would require a very different political perspective than what has been available in the past couple of years. So I don't think that will come very soon.
Yeah, and then it goes into the question, is it politics or is it legislation? And we could probably go down that rabbit hole for hours. But the power is sometimes with the worker, and a lot of the times with employers and managers. Can you share from your perspective what employers and managers should be mindful of when it comes to the individual rights of their workers?
The first thing that I would say is that on a very general level, if you're an employer or a manager, you should be mindful that you're in a position of responsibility with respect to actually upholding and advocating for the rights of your employees, which is a little bit different to what it's become in Australia. And I'm not just talking about the last couple of years, but there's this really antagonistic framing that's come in where it's employees versus employers. But historically, and in terms of just general human decency, that's not what it's supposed to be. Is supposed to actually advocate for the rights of their employees and to kind of be a custodian of those rights, because the employer recognizes that that employee is sacrificing something very, very valuable to them, which is their time. And for most people, time is our most valuable resource. So the employer, in exchange for that time and that labor, has a duty and a responsibility to actually uphold the rights of their employees. And I think that's a perspective that it's really important that employers genuinely hold, rather than seeing employees as a liability or as some kind of enemy. To go on a more practical level, employers have to be mindful of the rights of their employees. And when I say their rights, the Fair Work legislation is very particular, and they've probably heard about this on your platform before, but it's very particular about the protections employees have within the national employment framework and standards. You have to be very cognizant, especially today, of privacy law, discrimination law. You have to be very cognizant of the general labor rights and laws for employees in terms of their leave entitlements and things like that. As much as I have been sort of harping on about employers ignoring a lot of safeguards, there still are a lot of safeguards that apply to most situations that don't involve COVID-19. And in a lot of other human rights areas, such as discrimination, privacy, harassment, there is a general societal recognition that's covered those things, and things like sex discrimination, race discrimination, disability discrimination. There's a much greater awareness now of those things and of the laws, which actually are, discrimination law and privacy law, especially discrimination law, is probably the area of law in Australia that best enshrines the international human rights treaties and covenants, where domestic law actually enshrines those principles quite well and quite comprehensively. And individual employees usually have more options than they realize when it comes to challenging either a breach of privacy or some kind of discrimination that's occurred against them. Discrimination law in particular is really powerful because the definitions for the various forms of discrimination are very, very intentionally broad, and the avenues that are available to individuals to pursue those areas are generally no cost for them. So you can go to the Human Rights Commission federally or the various state and territory bodies, and you don't have to pay any money, and you don't need a lawyer as well.
Mm.
And it's not too technical, it's informal. Even if you lose, there's no costs order that's made against you. And for an employer, that can be a very painful process because employers tend to have lots of regulations in place that force that process to become more onerous, costly, and technical than it might otherwise need to be. So if I was advising an employer in that kind of situation, one of the things I usually say is, hey, you can hire an expensive top-tier external law firm and go to the Human Rights Commission, argue about how you're not actually liable for, discriminating against this pregnant lady or whatever, and spend $50,000 doing that, and then at the end of the process offer some small sum to the lady because you don't want it to go to court, and 12 months later you've added to your stress and your to-do list, and your organization's reputation is affected, and et cetera, et cetera. Or you can just have a conciliatory conversation with this person, hear them out, understand what they're actually gone through. Don't approach it as an antagonistic legal process, but instead approach it as a human rights-based process where, as the employer, you're trying to understand why this person feels like they've been discriminated against in this example. And then once they feel that they've been listened to, you might actually be able to come to some solution that's not combative and antagonistic. And on the commercial side, which is all they tend to care about, you're going to save yourself $50,000 to $80,000 and a lot of stress and headache. And even if you come to the end of that meeting and you think, I haven't done anything wrong, I shouldn't have to pay this person any money and whatever, think of it commercially if you have to, and just a whole situation to save yourself the energy and the time and the cost. But if you approach it more genuinely than that, it's probably going to have a better outcome anyway.
I would reiterate that. Listen, put your swords down, and you really identified what is a good employer and a good leader versus a bad one is whether you fight for or fight with your staff.
Yeah. It's like, are you a prison officer or are you an employer? Because an employer is not a prison officer. They're not your subject, or they're not your enemy either. They're somebody who contributes to your business, and like it or not, if they're not happy, there's an element, an arm of your business that's not happy. So yeah, absolutely.
And it's an opportunity to improve.
Yeah.
Most people just want to be heard. They feel discriminated, they feel harassed, they feel bullied, they feel whatever. You may or may not, as you said, you may or may not believe that, but just hear them out and actually listen instead of trying to be combative. And 99% of the time, you'll be able to come to an agreement or understand their perception and look to improve so that this doesn't happen with another person, with another team member.
Yes. And if you approach that, I agree, 99% of the time, 100%, that will be the outcome. There is another 1% of the time, even if it is that 1% of the time, if you approach it genuinely and you have that conversation or those conversations and you give it the appropriate time and you make sure you don't come in with any nefarious subconscious intentions or anything like that. Even if the person actually is a psychopath or vindictive or a liar or whatever, the fact of you doing that will help you later anyway. When you end up before a tribunal or the Human Rights Commission or the Office of the Australian Information Commissioner, if it's a privacy thing or whatever, they're going to love to see the record of that conversation where you were a genuine employer who had that kind of conversation. And it'll be difficult for the liar or the psychopath to to continue to do that in the face of such treatment. That's very rare, though, I have to say. I very rarely encounter an individual who comes to me for help and I have to say to them, hey, I think you're not being genuine. It's always misunderstanding, miscommunication, usually exacerbated by poor antagonistic communication between both parties. But generally, to be honest, the employer fanning the flames of discontent by being very over the top, authoritarian, disciplinarian, school principal, like abusive. Prison officer. Yeah.
Yeah. I was going to say, fighting fire with fire never works. It just makes a bigger one.
Yeah. And it's very expensive as well.
Yeah.
And in many ways.
Yeah. Taxing on individuals, like, it's not fun for anyone involved.
Yeah.
But just looking at the individual worker, what should they do? What's your advice for individuals if they feel like they've been asked to do something that goes against their morals or ethics, or they just have that feeling in the pit of their stomach that says, this is not right? What would you suggest for them to do?
It's difficult to answer that question generally, because as cliche as this is, every situation is very different.
Yeah.
If the individual knows that something is happening that they are not okay with, they have to put their well-being first. And depending on the options that they actually have available to them, they may choose to just take whatever step will immediately relieve them from the anxiety, the stress, the depression, the physical harm, whatever it is that is causing them to feel that way. On a legal level, there are lots and lots of options for employees, and all of them are pretty unattractive for employers to even have to deal with. So I actually would give the same advice to employees in some sense, which is it's a situation where you're being actually abused or just put in harm's way in some way, and you have the capacity to engage in a respectful dialogue with your employer. You have to try that if you haven't already, because while it might be less likely than the other way around to lead to an outcome, because you have much less, you're more vulnerable as an individual employee, it also looks good for you later if things escalate. Once you've tried that, you have to become educated about the various options that are available to you. You can do it yourself. You don't necessarily need a lawyer. There is a lot of good information online. Something that a lot of people don't realize about lawyers is it's not like we have access to things that you don't have access to. We're just used to looking at particular sources of information, but they're all available to everyone. And if you just spend a bit of time Googling as an employee what your options are, you'll come across everything. It just takes time and effort and energy, which you may not have. But if you do that, it will be well worth it, because it'll allow you to know which avenues are available. The main ones, very quickly, are there's the employment law, sort of traditional employment law avenues, where you can bring actions like a general protections claim, where there are certain protections that employees have under the legislation that an employer cannot breach. And if they take adverse action against you when you try to advocate for one of those protections or rights, such as, for example, if you try to take annual leave, which you're entitled to, and your employer takes adverse action against you as a result, or if your employer takes adverse action against you because you have a disability, so they're therefore discriminating against you, you can bring a general protections claim. Usually it depends on the individual circumstances. Those kinds of actions all go through either the Fair Work Commission or the Industrial Relations Commission. They're essentially tribunals that hear workplace disputes. It's quite combative. It's legalistic, even though they're supposed to be designed so that you don't have a lawyer, but almost always employers will have a lawyer. So there's that imbalance that's built into that system, unfortunately. That's one of the avenues. Another key avenue is discrimination law, where you have the Federal Forum, which is the Human Rights Commission, or the various state and territory bodies. In New South Wales, it's Anti-Discrimination Board. There's one in every state and territory. Less combative, little bit less legalistic, a little bit more conciliatory, especially the Federal Forum, the Human Rights Commission, no cost forum, and it adds a different layer to the dispute, because employers generally don't want to be seen as breachers of human rights or discriminating against people, especially the big ones, because they really care about their public branding and reputation. So even if the legal claim isn't that strong, sometimes there's scope to negotiate a resolution simply on the basis that they don't want to be seen as discriminating against women or discriminating against some kind of racial minority or whatever.
Mm-hmm.
So the third major option is privacy law. That's obviously specific to privacy issues, but there are separate forums. So you can go to the Office of the Australian Information Commissioner and complain that your privacy has been breached under the Federal Privacy Act. There are also state privacy acts. They're in the process of being changed at the moment, but not in a particularly bad way. The changes are generally okay. And there's quite strong protections for privacy in Australia as well, but the mechanisms of enforceability aren't very strong. So the Office of the Australian Information Commissioner isn't going to change your world with a resolution, but they might pressure the employer to stop what they're doing or to implement better regulations around privacy. And you might receive a very, very small monetary sum, but that's actually pretty rare. So there are lots of options is the summary. And the more educated you can be about what they are, the better your correspondence to your employer can be, because you can, for example, send them a letter which outlines the reasons why you feel you've been wronged and the various options you might take if they don't come to the table and negotiate with you. But before even doing something like that, which is something you might do yourself or you might have a lawyer do for you, it's usually better to try to work it out without threatening those things if you can. But sometimes you can't, and that's okay as well.
Yeah. And it all sounds a bit exhausting for everyone. So being able to have good relationships with your colleagues, with your team, with your manager, and have that conversation, as we were talking about earlier, will eliminate the majority of these issues. So if you can.
You always want to avoid any kind of litigation or even so these forums are all theoretically designed to not be those things, to not be litigation. But to be honest, you're right. They are stressful. Yeah. They take multiple months. They can all escalate into greater things if you're not sort of careful. So yes, having transparent, open, genuine relationships to the extent that it's within your power to do so, and bearing in mind your own well-being as well as what you're actually trying to achieve and what's the best way to do that, and making sure you try to respond rather than react can be very, very, very beneficial if you don't want to be stressed and anxious for a few months while going through a process. For some people, they want that. I mean, it's a bit of a generalization to say it's always stressful, but generally speaking, I agree with you that it's better to avoid all of those processes, especially because of what we talked about before with respect to the discretionary nature of the law and how it can be used against you. And depending on the context and depending on whether the thing that you're arguing about is trendy or has a particular societal preference in the way that it's interpreted, you might find that having a very good legal case plus very strong evidence doesn't necessarily mean that you're going to get justice in those forums. And there are limitations on what you can actually achieve as well. If you're unfairly dismissed from your employer, for example, and you make an unfair dismissal claim in the Fair Work Commission, the most you can receive is 6 months worth of salary. So if your employer, does the most unfair dismissal ever, you didn't do anything wrong, you're a top performer for 20 years, but they just decide they don't like you one day and they terminate you, or worse, let's say they terminate you because of some aspect of who you are or something like that. The most that you're going to receive in terms of restitution compensation is 6 months worth of salary. And that's actually really, really, really rare as well. So there are limits on those processes, and usually a more related approach can lead to more flexibility of outcome as well.
Mm. Yeah, and I think that's a really good point. Your mental health and well-being is number one priority. So you need to be selfish and put yourself first and understand what the different pathways or avenues might look like for you. So yeah, really great to highlight. So just to close off, what do you think the future looks like for workplaces in Australia? Can you answer that question?
Yeah, I can. I think it is in a period of major transition. So if we zoom out of the details and just look at the employment landscape, society itself is shifting so fundamentally that the nature of employment is necessarily shifting as well. But the old ways of doing things are kind of holding on and reluctant to change as it happens, and as a result, it's a little bit janky and distorted. But in that distortion and in that uncertainty, there is scope and opportunity for new growth and development and creativity, because everything's a bit looser, so people can create new ways of doing things, and that's what we're seeing on a collective scale. So people are no longer willing to be treated in a particular way by their employers. If they feel like they're being taken advantage of, they just leave. People don't mind being unemployed as much. There's not as much of a stigma around it as there was a couple of decades ago. People have more of an awareness of what their rights are. People have more of an awareness of the law as well. I said before, it's good to become knowledgeable. People are pretty knowledgeable about the law these days, and there's less scope for an exploitative, abusive, power over dominance type relationship, which is the paradigm that we have existed in for, I would say, a couple of thousand years now in that employment law relationship. That's shifting to something that's a lot more collaborative, communal, creative, even matriarchal as well. There are broad shifts going on that I think are ultimately going to be better for everybody, whether you're an employee or an employer. Whether those labels even apply anymore is questionable, but fundamentally, I think the whole system is necessarily shifting and changing in the short term. And I don't know how short it is. It's really hard to tell. It's just a continuation of what we're already seeing, which is people are generally becoming more individualistic and autonomous in the sense of what they want, but more collective in the way of doing business. There's more sharing and communion going on, rather than hierarchical, one person decides how things are going to be and everybody else says yes. That doesn't really fly anymore. So I don't know exactly what the future looks like, but I know what the themes of it are. And the employers that adapt to that might survive. But otherwise, I think we're moving into a lot of new stuff, including whole systems and structures and ways of doing business. And as a result of that, new businesses. But I don't know if they're going to be businesses in the sense of how we currently define them. I think they're going to be something much newer than that, and more adaptive, more flexible, more creative, more communal as well. I could be wrong. That's just what I think.
Oh, I'm a glass half full kind of person, so I love that positive view. And yeah, we are in a period of transition, and people expect flexibility. They expect to be treated with respect, and it's against the law to be disrespectful, to be bullying someone, to discriminate for silly reasons. And yeah, so if this is going to pave the way and open for change, then I'm all for it. And I love your perspective on that. So thank you so much for sharing.
No worries. I'm glad you agree.
Yes, 100%. I just want to say a huge thank you for joining me, Peter, and for your perspective on the law and the legislation. And thank you so much for coming on and sharing.
My pleasure, Nicole. Thanks for having me. And keep doing the great work that you're doing.
Thank you. You too. And if anyone wants to connect with you, I recommend find you on LinkedIn and visit your website, martsmethod.com.au.
Yes, you can find me there.
Great. Thanks, Peter.